Hi, my name is Robert Chelle with Chelle Law, and my firm assists physicians with employment contract issues. One question that comes up frequently is what's the difference between an offer letter and an actual employment contract? And then is the offer letter binding? Some employers will ask that the physician sign an offer letter. And the offer letter dictates kind of basic terms of the agreement. So generally, salary, any other kind of compensation, signing bonuses, relocation assistance, maybe getting into the benefits of PTO, what they'll pay for as far as dues and fees, maybe what the basic terms of the non-compete are. Very base level things, like one sentence, like your PTO will be 30 days, or your base compensation in year one will be, whatever, $300,000. So many places don't want to go to the, through the hassle / expense of drafting an employment agreement if they can at least come to term on the basic level of what will be, in the employment agreement itself. Now, many physicians will ask, okay, I have signed the offer letter. I now have the employment agreement, and after reviewing it, I don't like what's in there. Or maybe it's substantially different than what was in the offer letter. Am I bound to the offer letter? And the answer to that is no. Although the basic terms have been agreed to and will then be incorporated into an employment agreement, there are simply so many complicated and nuanced things that could be an employment agreement that after reviewing the basic terms, the job looks great, but then getting into the actual details of the employment agreement, the job doesn't look so great anymore. So usually the areas that, might not be in the offer letter, but might make an employment agreement terrible, would be the kind of nuts and bolts of the non-compete and non-solicit. If the offer letter says it's 1 year and 5 miles, well, then when you get into the agreement, when you get into the details, it's 1 year, but then it's 5 miles from every single facility that a healthcare network owns. And so one location for 5 miles is usually reasonable. 100 locations for 5 miles obviously is not. And that in itself can be, there's for a physician, an absolute no. I'm not signing this agreement if it has this. Or maybe if someone's on like a net collections based compensation structure for a contract, and in the offer letter it says you'll get 40% of all net collections, but then in the actual agreement it'll say, but when the contract terminates, you won't get any collections after that. And so the physician in that scenario would be essentially working for free for the last 3 months because they wouldn't get anything that they produced and collected after the contract ends. And that can be an absolute no, I'm not signing this. So in short, no, the offer letter is not absolutely binding. Things can absolutely change from the offer letter into the details of the actual employment agreement. And it is well within the rights of the physician, after reviewing the details of the employment agreement, to tell the employer, I'm not going through, or at least negotiating some changes to make it palatable to them, and saying, although I signed the offer letter, I understand that, but I'm not signing this agreement. And there's not much the employer can do about that. So if you have any questions about physician contracts or potentially have an offer letter you'd like reviewed, we certainly are happy to assist with that. You can reach us at the telephone number listed below in the description, or reach us on our website, chellelaw.com, CHELLE law.com. And hopefully you found this video helpful. And take care.